coming for our hate crime event. We're going to learn more about the legal requirements and the generalities and from the FBI perspective of hate crimes. And he's familiar with the city of Jackson and the law enforcement in the city of Jackson. And Supervisory Special Agent Patrick Geahan is the current head of the FBI office in Ann Arbor, covering Jackson, Washtenaw, Livingston, Lenawee, and Monroe counties. His previous assignments have included time as investigator of crimes against children, computer intrusion, and counterintelligence, as well as stints as an FBI instructor and undercover agent. Supervisory Special Agent Geahan holds a bachelor degree in computer science from Michigan Technological University and a master's degree in information security and assurance from Carnegie Mellon University. He is the 2019 recipient of the FBI's Medal of Excellence and is the 2020 finalist for the President's Cup for Cybersecurity. And Brenda and I know him from working on LPAC for a while now, and we're very pleased that when he said yes, he'd come speak to us. So please take it away, Special Agent Geahan.
Well, thank you very much. Appreciate it. And please, everyone, call me Pat. No need to stand on titles here. Thank you for the time and the opportunity. One of my goals since taking over this office a year back was to increase our office's investigation of and prosecution of hate crimes and other civil rights-based crimes. We've had some success there, which I will talk about as I go through. But my primary goal here today is to talk to you folks about how and when we as the federal government decide to step into something. And that is mostly going to be a discussion of the legal framework surrounding what the federal government defines as a hate crime or a civil rights crime. So a couple notes before I share my presentation and get started. There will be time at the end to ask questions, a general time. I am also happy to entertain questions as we go. However, because of the issues with doing this over Zoom, if you have a question, please type it into the chat box instead of trying to do it vocally. The problem with doing it vocally is oftentimes I can't hear you because all I can hear is myself. My wife says that's a problem that I have in my whole life, but I'll definitely have it tonight. So I'm going to type a message in the chat box. Please raise hand here. Okay, so if you do have a question as I'm talking, please just type in the box that you have a question, and then I'll call on you and you can explain it to me. I'm going to share my screen here. Maybe. Okay. All right. So can everybody see my screen?
Yes.
Yes.
Okay, good. Thank you. All right, I'm just going to make a couple of adjustments here for myself. All right, and let's get started. So one of the first things we need to talk about as we talk about civil rights and hate crimes is the idea of dual sovereignty, okay? As most of you are likely aware, there are multiple different legal systems in the United States. Every state and every territory has their own, and then the federal government has one that's sort of overarching, okay? State crimes revolve around violations of state law, and they occur on state property. Now, let's be clear that by that we mean state sovereign property, not owned by the state, but controlled by an individual state, okay? Federal crimes are either violations of the US Constitution or specifically written federal crimes violating federal law that either occur on federal property or occur in interstate commerce, okay? We talk about this because virtually everything that we discuss as a hate crime or a civil rights crime is a state crime, okay? So the state can, in nearly all circumstances, they can charge that as the underlying crime. So for instance, when we talk about hate crimes that revolve around assaults, the state can charge that as an assault without ever discussing it as a federal hate crime, okay? So oftentimes you will see, something that you think may be a federal hate crime, but it only gets charged as a state assault. We can charge both, okay? So we can have a state charge and a federal charge on different things. But I want to point out something very significant here when we talk about violations of federal law. You'll note that violations of federal law either have to occur on federal property or within interstate commerce, okay? So if we don't meet one of those two crimes, in most cases, we can't possibly prosecute. So let's talk about what counts as interstate commerce. So the US federal government derives part of its authority here from interstate commerce. There are several ways that we can identify interstate commerce in a given prosecution. One of them is that the defendant uses a weapon which is traveled in interstate or foreign commerce, okay? What does that mean? Well, it means that if you use some kind of weapon in the commission of a crime that was produced in a state other than Michigan. When I've prosecuted crimes like this in the past, for instance, when we've prosecuted crimes that are committed by someone using a Glock pistol. Glock pistols are all manufactured in either Smyrna, Georgia, or in the country of Austria, okay? So that gun traveled in interstate commerce. The subject or victim crossed a state line or national border in connection with the offense, okay? It's the in connection of that gets important here because merely traveling from one state to another and then becoming a victim of a crime doesn't necessarily lend to an interstate commerce call here. One thing that you will see that we specifically see in this corner of the state that's very interesting is that we often saw people, especially last summer with all of the civil rights protests that we were seeing, we would see people drive from, say, Toledo to Jackson or Toledo to Detroit to participate in a protest. Even though the distance is very short, that would still count as crossing a state line or national border for these purposes. Okay. The crime occurred in a train station, bus depot, or on an interstate highway, excuse me. Those all lead to a potential ruling for interstate commerce. A train station or bus depot are both in part looked over by the federal government, so interstate commerce can attach there. Okay. The crime interrupted the victim from engaging in business. Now, there's some caveats here, that we have to talk about when we talk about actual interstate commerce, but this is one of the possibilities. If we do some kind of attack that stops somebody from engaging in normal business and normal commerce, we can see pretty easily how that would count as interstate commerce. The crime otherwise affects interstate or foreign commerce. That's a very broad statement there, right? It's worth noting that in the original Constitution where we defined interstate commerce, we did not define it terribly well. And so most of what we're seeing here has come across over the years and has been defined by district courts or the Supreme Court as cases have come up and rulings have been made. All right, so now that we've gotten the beginning part out of the way, let's talk about actual hate and civil rights-based crimes. So we're going to talk about four categories, four specific statutes here as we go through this. We're going to talk about the Shepard-Byrd Act, which is probably the most commonly charged one, and I think the one that's most relevant to you folks. We're going to talk about some of the statutes regarding interfering with religious activities. We're going to talk a little bit about interfering with federally protected activities, and then we'll talk about color of law violations. Okay. All right, so let's start with Shepard-Byrd is a very recent addition to the federal pantheon here. Shepard-Byrd was signed by President Obama in 2009. It expanded the possibilities for federal criminal cases based on certain protected classes, including, at the time, sexual orientation and gender identity. We had never before had a federal statute that allowed us to prosecute hate crimes based upon sexual orientation. In fact, as an interesting point this morning, when I was talking about this, one of my agents here in Ann Arbor told me about a case that he had way back in 2003 when he first joined the Bureau that involved a pair of homosexual men being stoned by an anti-gay activist. And I mean, literally stoned, like he got a pickup truck bed full of rocks and threw them at him. Even though it would otherwise qualify under hate crime legislation that existed at the time, it did not qualify because at the time we did not protect sexual orientation as a protected class. Both sexual orientation and gender identity are now protected classes under Shepard-Byrd. And as I think most of us know, Shepherd Bird was named after Matthew Shepard, a Wyoming resident who was murdered because of his homosexuality, and James Bird, a man who is an African-American man who was dragged to death by 2 white supremacists. All right, so let's talk about what Shepherd Bird actually does and when it does and doesn't apply. So Shepherd Bird is divided into 3 parts. We're going to talk about each one individually. The first part is racial crimes, okay? That is anyone who willfully causes bodily injury to another or tries to do so because of that person's actual or perceived race, color, religion, national origin. So the very first thing that I want to point out here is the word perceived, okay? We do not have to prove as part of this case that the person was actually a member of that race, actually had that color, was actually a member of that religion. It is perception that is important, and specifically the perception of the attacker. I will give you one place where this has come up a lot, especially post 9/11. Post 9/11, we saw a rise in hate crimes against Muslims, okay? There are a lot of, uneducated people who confuse Muslims and Sikhs, okay? Sikhs wear a fairly complex turban. Muslims tend to wear a hijab or something similar. We saw occasions where someone would attack a Sikh thinking that they were Muslim. The perception that they were Muslim was enough. They did not get off simply because they were wrong, okay? This particular category, again, has 4 sections: race, color, religion, national origin. This particular section, we do not have to prove any other jurisdictional element. So this is one of the few times where that interstate commerce piece does not come into play. And that is because of the 13th Amendment. The 13th Amendment to the US Constitution specifically empowered the federal government to fight what they call badges of slavery, which is a very weird statement, and I don't explain how that came about. But as part of that, it specifically enabled us to fight racial crimes that did not otherwise have one of our standard jurisdictional elements. So anytime we have someone causing bodily injury to another person because of that person's perceived race, color, religion, national origin, we can take the case federally. I will give you an example of that, one that is currently being adjudicated, and I will give an early disclaimer, which is that because this case is currently being adjudicated, the person has not been found guilty. I will talk about the case as if the facts have already been determined, mainly because that just makes it easier for me. But do keep in mind, he's innocent until proven guilty, has not been proven guilty. Having said all of that, last summer in Monroe County, we had a situation where a white gentleman said some very awful racial things to a group of African-American teenagers. And when they spoke back to him, he took a bike lock on a chain and beat one of the young children with it. Young children. He's 18. I say young because I'm much older than that. But he caused some very serious injuries to this young African-American gentleman. This was done on the grounds of a state park. Was not in any way in interstate commerce. Even if we really ate our Wheaties, we probably couldn't prove that up. But we have charged him with a federal hate crime under this statute simply for that. That is one place where we can do that without that interstate commerce element. And as we go on, I'm going to talk a little bit more about that case specifically so we can discuss why we took that one and maybe why we don't take others. All right. So the second piece of Shepherd Bird is non-racial crimes, okay? So these are ones where we can prove willful cause of bodily injury to another, or again, an attempt to do so, because of that person's actual or perceived gender, disability, sexual orientation, or gender identity, okay? Now, this particular part, this second part 2, because we don't have the 13th Amendment to cover us there, this one we do have to prove interstate or foreign commerce, okay? Or it has to be on federal land. If we take another look at that case I just spoke of, if the assault had been done because the person was transgender, instead of the person being African American. If it was done because the person was transgender, we would then have to prove that it affected interstate or foreign commerce or was on federal land in order to be able to prosecute that. This has come up in many cases where we deal with LGBTQ type violence, right? If we think back to the earlier example that I had about the two homosexual men being assaulted by someone with rocks, we may struggle to find a nexus for interstate or foreign commerce there, because rocks are local, right? Not to say that we couldn't do it, but it definitely makes it harder. Okay. So again, in this one, we have to prove interstate or foreign commerce, or it has to be on federal lands. This one covers gender, disability, sexual orientation, or gender identity. I will again highlight here the use of the word perceived. We've actually made several prosecutions based on this, where someone has been assaulted. Generally, a person who's perceived to be LGBTQ, who is assaulted for that, even though they are not necessarily themselves LGBTQ. We don't give them a free pass for that. It's the perception there that counts. The third part of Shepherd Bird, any of the stuff that we described in number 1 or number 2, any of those protected classes, still here we don't have that interstate commerce clause requirement. So if something like that was to occur, as an example, inside of a federal building, on federal land, which would include, say, the land owned by the VA here in Ann Arbor, or any national park, we can apply this without otherwise having that interstate commerce clause. We do still have to show that the assault was because of membership in a protected class, and we will get to explaining more about that in just 1 minute. Before I move on to talking about the problems we have in prosecuting Shepherd Bird, does anybody have questions about the legal definitions for Shepherd Bird? Okay, Shelby, looks like you've raised your hand. Go ahead and ask your question there.
You're still
I think you're on mute, Shelby.
You can unmute. Or put it in the chat, either way.
Either way. All right, Shelby, while you figure that out, we will come back to you and get that question. Any other questions? Okay, so let's go ahead and talk a little bit about what happens after we gain a conviction in Shepherd Bird. So Shepherd Bird does not have a misdemeanor component to it. There are federal misdemeanors, although they're rarely charged. There is no misdemeanor charge for Shepherd Bird. It is always a felony. The maximum imprisonment without aggravating factors is 10 years. Generally speaking, we get people, on the low end, 2 to 3 years with this. 10 years is a little bit rare. It can increase to life if death results or the offense includes one of these aggravating crimes: a kidnapping or an attempted kidnapping, aggravated sexual abuse or attempt thereof, or some kind of attempt to kill. All right, so okay, so let me come back and take care of Shelby's question here. What if someone was hurting someone else that was presumed to be disabled and a person of color? So Shelby, is your question whether or not the penalties are enhanced for that? Okay, so in the case where we had a person who was assaulted because they were disabled and because they were a person of color, that would aggravate the sentencing when we came to that. So we could conceivably make one charge of violating 18 U.S.C. 249 and then aggravate the sentencing at the end. We could also charge both of those things separately, okay, depending on exactly how that came about. And when you charge two things separately, you have the possibility of getting double the sentence, right? So if I was charging someone with two charges of 18 U.S.C. 249, they could get up to 10 years on the first one and up to 10 years on the second one. If we gave them one charge, they could get a maximum of 10 years. But having both of those biases, I guess, that would potentially increase that one sentence to closer to that 10-year line. So I have a question here from Carol. What is the definition of aggravated sexual abuse? I don't have a specific definition for you. As a general case, we consider sexual abuse to be aggravated when it includes some significant level of violence or injury or death occurring as part of that. The line that would sort of be drawn there would be drawn perhaps between a sexual abuse charge that maybe doesn't involve contact or doesn't involve serious injury. Child pornography would be a great example of a sexual abuse charge that is not considered aggravated. Aggravated would require that extra injury, violence, something like that. We also would generally consider it aggravated when it occurs as part of something else. So if there was a kidnapping that included sexual abuse during the kidnapping, we would generally consider that aggravated. That answer your question, Carol? Okay. All right. Anybody else before I move on? Okay. Seeing none, let's talk about the challenges for Shepherd Bird. Shepherd Bird is a wonderful piece of legislation, but it's not without issues. So first one we'll talk about here.
Yo, I'm just doing a solos match really quick because I saw that you were in a duos match.
Yeah, after this game, I'll join your party. 'Cause
I think somebody has a hot mic out there. If you could check your mics and mute them for us. Okay. So biggest challenges for Shepherd Bird. First of all, Shepherd Bird only covers acts of violence causing bodily injury. We do allow attempts for that, but it still has to be a violent assault, if you will. It doesn't have to be a lot of bodily injury. So we can talk about cuts, abrasions, bruises, even physical pain that doesn't cause actual bodily damage. That all counts. It doesn't cover emotional or psychological pain. So one of the types of reports that we will regularly get is somebody will say, look, I am a person of color, or I'm LGBTQ, or I'm something like this. And I was walking down the street and somebody yelled a slur at me, directed at me, an awful slur, fill in your own slur there. Can we prosecute that? And under Shepherd Bird, we cannot. It has to be bodily injury. It does not in any way cover emotional or psychological pain. Now, having said that, trauma that results from a bodily injury is relevant in a prosecution of Shepherd Bird. We cannot simply base a prosecution solely on that, okay? The second one, and the one that honestly causes us the most trouble here, are these two words, because of. Now, I don't know how many of you on this call are lawyers or who've spent a lot of time with lawyers. I'm swallowing all of my lawyer jokes because I don't know all of you well enough yet. But we all know what the words because of mean. But in lawyer terms, they mean all kinds of crazy stuff that we just can't figure out. In all of these cases, we need to prove that the assault was done because of someone's membership in one of these protected classes. It is the because of that causes a lot of issues. I will give you a wonderful example. Let's say that I go to a bar and I bump into someone of a different race, and we exchange words and we get into a fist fight, okay? That is not a hate crime. Even though we're of different races, that is not a hate crime. In order for it to count under Shepherd Bird, we would have to prove that I assaulted this person because of his race. Not simply because he's of a different race, but because of his race. It requires evidence that this action would not have taken place if not for that prescribed motive. Okay? This can sometimes be very, very difficult to prove up, right? It is often difficult to prove what goes on in someone's head. Now, if we talk about this assault that I was speaking of in Monroe over the summer, we have someone who was yelling racial slurs. We had someone who was making other comments about Black Lives and Black Lives Matter and all that. It's not difficult to prove that that person had a racial motive there. In other cases, it's more difficult or impossible. I will give you one example that you folks may have heard of also from last summer. Last summer, we had an incident where there was a racial justice protest. I believe it was in Jackson City, but please don't hold me to that. A gentleman drove up to the protest, which was blocking an intersection. He had words with one of the people there, angry words. He then drove off and then came back and hit that person with his car. Okay. that was referred to us for potential hate crimes prosecution. We were not able to take that. And the primary reason we did not take that is this because of segment, right? We would have to prove that he assaulted that person because of that person's race, color, religion. You see the list, right? It cannot be simply because that person was of a different race, of a different color, something like that. In that case, it was just as easy to believe that this guy was road raging as it would be that it was hate crime. So one of the things that we did as part of that investigation was we took a look at this, at the driver's social media accounts. We took a look at his history. We took, a look at all the background that we could find on this person, and we found no evidence of any kind of racial animus or even animus against Black Lives Matter or protesters in general or any of that. So that because of is what tripped us up there. We will talk a little bit later about other ways that we maybe could have prosecuted that. They also didn't pan out, but we will talk about that. So it's that because of that comes into play. All right, so I have a question here from Reverend Miyake, and I apologize if I biffed that pronunciation. So your question about a white woman who assaulted a African-American teenager because she thought that he stole her phone, would that qualify as a hate crime? Well, maybe, okay? So again, with the because of, right? What we would have to show here is not just that there was a different potential motive there. We would have to show that she went farther than she normally would have and caused a bodily assault differently than she maybe would have for a white teenager, okay? So the fact that, if we take race out of this for just 1 second, we talk about, this woman approaching this young gentleman, thinking that, that he has her phone, trying to take that phone from him or trying to prevent him from leaving or something like that. Obvious crime here, right? Unless for some reason it counts as a citizen's arrest, which I'm 99% sure it doesn't. Obvious crime there, obvious crime of assault or battery there. What we would have to show is that if that was a white teenager or a teenager of any other race, that wouldn't have happened, that she would have handled it differently. Tough to prove, obviously. We would, again, take a look at conduct. We would take a look at statements made on scene. We would take a look at, who she was, where she came from, all of that. So yes, a potential hate crime. We just have to prove that it was motivated in some way by an animus towards that person's protected class. Okay. All right. So that's actually an outstanding question, Reverend Miyake, because it goes wonderfully to the third problem with challenges for Shepard Burton, which is the idea of competing motives, right? We talk a lot in the world now about latent racism, right? About ingrained bias, right? About all of these issues that come up in a system that is in and of itself often, racist and problematic, right? So we don't have to have something like racial slurs. We don't have to have somebody coming out and saying on Facebook, I dislike this group of people. We do have to prove that it is a significant motive, that it is part of this. But oftentimes you have these competing motives, right? To go back to this protester that was injured, our balance was, did he assault the person because he was a protester, which may fall under a different federal crime? Did he assault the person because he was of a different race or a different LGBTQ group or a different religion? Or did he assault him just because he's a jerk, right? And like, being a jerk isn't a hate crime. We have to prove that extra piece in there. And in some cases, we do see overlapping motives. We will see something where, somebody assaults someone else in a manner that you could argue that their original motive was a simple assault, a simple state assault, but then we can prove that it went farther because that person was of a specific racial group or other group. We have seen that quite a bit when we've talked about the term disrespect. That seems to pop up a lot in these cases where someone will find themselves, will feel themselves disrespected by someone else. And then that will lead to that. Disrespect is frankly, in a lot of cases, just code word for racist. And that's a competing motive that we have to deal with. It is worth pointing out here too, that when we talk about competing motives, we do have to think about putting this in front of a jury, right? So decisions about whether someone is guilty or not guilty are not done by me, and they're not done by prosecutors. They're done by a jury of 12 people. So even if we firmly believe that this was done for racial reasons or for LGBTQ reasons, we may decide that we can't get it past a jury, or the jury itself may not agree with us. And that's where these things come out. What we will often see in cases where we do prosecutions under Shepard-Berg is we will see the defense come in with a defense that is basically, look, my client did the assault, but it wasn't for racial reasons. It was just because he didn't like the guy. And we have to work with that. Okay. Questions about Shepard-Berg challenges before I move on? All right, so I will give one caveat to all of the things that I just said. And the caveat is this. Hate crime legislation is constantly changing. In fact, we saw hate crimes legislation start to change today when the House passed a bill firming up some of the protections for, I believe, both gender identity and sexual orientation, although I have not read the bill. So some of this may change like on Monday. We never know. One of the wonderful things about being in the service of the U.S. Congress is sometimes they just write new legislation. It's great that we're taking that more seriously, but it is annoying sometimes when I have to rewrite these presentations every month or so. All right, so let's talk about color of law prosecutions. So these are the ones that the people often bring to my office. So color of law violations deal with constitutional violations. In order for somebody to be charged with acting under color of law under 18 U.S.C. 242, we have to meet a series of elements. So first of all, they have to be acting under the color of law. What does that mean? They first have to be a government official. Okay, so we can't do a color of law prosecution on just Joey bag of donuts. They have to be a government official. They have to be using, abusing, or pretending to use power given by the government. The pretending by is important here. Okay, we often talk within my line of work about scope of employment. Okay, about scope of duties, and what that means is there are certain things I'm legally allowed to do or investigate, and certain things I am not. Okay, so as an example, in the state of Michigan, I am not a state peace officer, so I do not and cannot enforce state law. Other states are different. When I was in Illinois, I was a full peace officer. I can't do that here. I cannot, for instance, arrest someone for shoplifting in this state in most circumstances. Okay, if I do so, I am no longer acting under my scope of duties, and my agency would not support me in that. If I did that, however, even though it's not part of my actual duties, I would still be liable under a color of law violation because I was pretending to use power given to me by the government. So if I act as if I have the power as a government official for purposes of this law, I do. Okay. This can occur whether I'm on duty or off. Okay. It just has to be a government official. And we mostly think of this in regards to the police, but this applies to any government official, whether they be prosecutors, judges, probation officers, all of that. And Regina, I do see your question there. Let me get through 242 and I will come back to that. Okay. So again, any government official, whether local, state, or federal, this does not just apply to federal officers. Okay. The second piece, the government official has to have acted willfully. Color of law violations do not arise from accidental, negligent, or even reckless conduct. In most cases, when we talk about accidental, negligent, or reckless conduct, we then talk about a potential civil suit, not a criminal charge, which is what I'm talking about here, a potential civil suit, a lawsuit, okay? In other words, we have to prove that the defendant knew what he or she was doing was wrong, and they did it anyways, okay? Now, when we say they have to know what they were doing was wrong, we don't specifically have to prove necessarily that they've been told this thing you're doing is wrong. We need to prove that they knew or should have known based upon training and experience that what they're doing was wrong. All right. Oops, sorry. Okay. 3, they deprive someone of their rights under the U.S. Constitution or rights granted under U.S. law. Okay, this ends up being fairly broad, especially when we talk about police officers and other law enforcement officers, because in almost any occasion where a law enforcement officer encounters someone, prevents them from leaving, uses violence on them in any way, they are committing what we call a taking under the Fourth Amendment. Okay, so an arrest is covered under the Fourth Amendment. That's why we have to have probable cause to arrest someone. Same thing with any other sort of violent action taken. It could be a violation of either the Fourth or the Sixth Amendments. But we do have to prove that they deprive someone of their particular rights under U.S. law or under the U.S. Constitution. All right. So Regina, let me come back and answer your question here. So we become. Okay, so the question here is whether I think the laws we're talking about are fair or more onerous than necessary. It's kind of a difficult question to answer. When I look at the construction of these laws, I think based upon the federal system, that they're about as fair as they can be. Where I think we need to strengthen them in a lot of ways is balancing out the different forms of discrimination so that we can balance the different protected classes better. As we see before, racial crimes are much easier to prosecute than other protected classes. They're easier to prosecute than gender-based crimes or sexual identity-based crimes. I'd like to see that balanced out. We do see a systemic racism problem in the legal system. I would never deny that. Unfortunately, I think more of that rests with the judiciary and the application of those laws rather than the actual statutory construction. I think most of the statutes say things the right way. I think it's law enforcement officers, it's prosecutors, it's judges who are charged with applying the law to these defendants that we see more of that come into play. Just as a general statement, we will see lots and lots of situations where we see an African American person, for instance, charged with something that a white person is also charged with, and we see disparates in sentencing. Those sentences are legal, and I mean that from a purely statutory standpoint. They're both legal sentences, and nothing violates statute, but it's the racial disparities in the application that become problems. How we solve that, I don't know. I think if I could come up with that, I'd be making a lot of money selling that to people. But yeah, I think the statutes are in a good place. We need to push for more prosecution, better prosecution, and then an overall better prosecution in sentencing at the racial level. That answer your question? Yeah. Okay. Yeah, I went on a little bit of a rant there, but there we go. Okay, so any questions about color of law before I move on? All right, seeing none, let's move on to the next statute here, which is federally protected activities. Now, we talk about these federally protected activities. This has come up a lot in the last few months with all this stuff with the U.S. National elections, state elections, state election board stuff, and all this stuff. So we separately criminalize federally protected activities. So the first way that we can criminalize this: willful injury, intimidation, or interference, or attempt to do any of those, and force or threat of force in any of the following circumstances: voting or qualifying to vote, participating in any program provided or administered by the federal government, applying for federal employment, just being a federal employee, juror or prospective juror in federal court, or participation in any program receiving federal assistance. So what does this mean? It means that anytime somebody tries to interfere directly with someone voting through force or threat of force, that's a federal crime. Okay, it's a federal hate crime. It's a federal civil rights crime. I have to differentiate between the two. Any kind of interference with any federal employee, okay, that's a civil rights crime, right? Juror, prospective juror in federal court. One of the ones that I like here is a participant in any program receiving federal assistance. One of the places that we have used this in the past is to push back on places or people who try to stop folks receiving social assistance, right? Commonly called welfare, right? SNAP, any kind of those benefits. Places where people try to physically stop someone from participating in or being part of any of those programs, that is a federal hate crime. In this case, a federal civil rights crime. I've got to get that right. In this case, we derive that directly from that federal participation in these things. Okay. Remember, we can protect federal programs and we can protect people from constitutional violations. Here, we're dealing specifically with federal program. We tend to cover this fairly broadly. So any program receiving federal assistance, I know many of you here are in various social work or justice type roles. Think about any program that you guys run or are part of. If you can name one that doesn't get some kind of federal assistance from somebody, I'd be surprised, right? We give away tons of money to all kinds of groups, grants and funding and all this stuff. So that's actually a fairly broad category. Okay. The second piece, willful injury, intimidation, interference because of protected class membership and any of the following: student or applicant in any public school or college, participant in any program provided or administered by the federal government, application for any employment, juror, prospective juror in state court, traveler, user of any facility in interstate commerce, a patron of any public accommodation. So let me differentiate between 1 and 2 here a little bit. Okay, let me flip back to 1 real quick. Okay, number 1 requires force or use of force, but does not require membership in a protected class. Okay, so here you could, if you're going after, white cis hetero men, okay, which are like the least problematic class from a hate crime point of view. Force, threats of force, no problem. Second one, it has to be because of protected class membership. Okay, so that's the big difference between 1 and 2. So in this one, right, we have to prove that the discrimination was because of a membership in a protected class, but it doesn't require violence or the threat of violence. Okay. So for instance, in this one, if I was a registrar at a college and I was taking applications from LGBTQ students and throwing them in the trash, that would count under this statute. That is a federal civil rights hate crime. Same with application for any employment. It also definitively applies to juries, prospective jurors in state court. Now, we don't see so much of that anymore. We used to see that very much during the civil rights era of the 1960s and 1970s. We saw a lot of places that would simply bar African Americans from sitting on court, right? There are judicial remedies for that within the judicial system. We can also do that here. So Carol, let me come back to your question here. Why would that not cover protesters who block people going into Planned Parenthood? Very specifically here, it would cover them, but we have a completely separate set of legislation that deals with access to clinics. It's called the FACE Act, Free Access to Clinic Entrances, which provides stiffer penalties for abortion specifically. I don't talk about FACE in here, just because I had to kind of cut it down. But this would apply to abortion clinics if they receive federal funding, which I'm pretty sure all of them do. But it's covered separately under a separate set of legislation as well. Does that answer your question? Okay. All right. So we've covered this one here. Do we have any questions about federally protected activities before I move on? Okay, seeing none. The last one we're going to talk about here is interference with religion, specifically interfering with religious activities. There are 2 coverages here. The first is the intentional defacement, damage, or destruction of religious real property because of the religious, racial, or ethnic characteristics of that property. Okay, so why do we say it this way? Okay, well, first of all, this one doesn't apply to digital property, which I think is a bit of a hole in this legislation. This was passed well before the internet was a thing, so I suspect that may get fixed at some point. But again, note the use of because of. We have to prove that something was done because of the religious, racial, or ethnic characteristics of that property. We throw both racial and ethnic in here to cover people who, and we've seen this before, right? People who will attack, say, an African-American church, but wouldn't attack the white version of that same church, okay? Still religious discrimination. We just toss that in to make sure that we don't have to necessarily prove that they were biased against that particular religion, okay? Note again, with the because of, we have to prove that this was done for that reason. I will give you an example. We had a case not too long back where somebody reported to us that a local synagogue had been defaced. And normally that could fall under this. What we found, however, was that there was a rash of defacement attacks that evening, which covered storefronts, it covered schools, it covered the synagogue, it covered a church. There were a dozen places that had been tagged. In that case, we can't really say that it was because of the religious, racial, or ethnic characteristics of that property. Where that may differ, though, is if the particular graffiti was specific to that religion. I'm going to go back to the synagogue example because it's an easy one to remember. But if, say, somebody was defacing all kinds of businesses and all kinds of buildings, but they spray painted a swastika on a synagogue, well, suddenly that comes back to racial, religious, ethnic reasons, okay? It's worth noting here that when we take a look at cases like this, we do take a look at them as a totality, everything that goes on, everything that's said, everything that's done. The second one, intentional obstruction by force or threats or attempts to stop the free exercise of religious beliefs, okay? So that covers any kind of exercise of any sort of religious whatever. Again, post 9/11, for those of you that aren't familiar with some of the tenets of Islam, they're required to pray multiple times a day. We saw people being assaulted post 9/11 for simply praying in a public place where other people could see them. That counts as number 2 all day long. It would also count if someone tried to prevent someone from going to a church, going to a synagogue. We have also used this to prosecute people who say burn down a church, right, or burn down a synagogue, or otherwise destroy religious implements or something like that. All of that would sort of fall under this. Okay. All right, so I've spent the last 45 minutes, give or take, vomiting a whole lot of legalese at you. That's kind of the end of my prepared remarks. Let me turn to questions, and I do see one question here. Was the Dillian Ruth case prosecuted as a hate crime? Frank, I apologize. I'm not familiar with that case at all, so I can't answer that question for you. Do we have other questions out there about anything that we've talked about here? Or anything else you want to ask me?
There's another one by Dan as well.
Oh, let me zoom it. Oh, okay. Thank you for that. If my church flies a BLM banner or pride flag and our property got vandalized, that would count, right? I would believe that it would, because it's religious, real property. I would have to give you just a tiny bit of a question mark on that because I've not done the research to determine whether it has to be specific to that religion. But my understanding would be yes, it would count if it was flown on, the church property or on the church building or something like that. It would not count, for instance, Reverend, if it was at your house, right? If you put a pride flag up on your house and your pride flag gets vandalized, we'd very likely not be able to call that religious real property. If it was flown on the church's property, we would probably be able to pull that off. All right. Other questions?
I've got one. Since I'm
Absolutely.
a media junkie, how often does social media get used for that because of that proof that their social media language, they are those?
So, I can't give you like a percentage number. I can tell you though that it has become incredibly important in the last several years. as I had said before, one of our issues with this has always been, how do we prove that someone has that bias in their heart, right? We can't just go on, a different, difference in races or difference in, gender or, whichever protected class you want to throw in there. We have to prove that because of. And what's been wonderful about social media is actually the same thing that I hate about social media, which is the things I say never go away. But we have seen where people will say some horrible things and then will delete their social media after they do something bad, and we can go back and retrieve that. And so from that, it's become very, very important, especially when we talk about, a lot of this, this civil protest that occurred last summer when we talk about, the various killings of African Americans by law enforcement. One of the things that's popped up in that is we've seen a lot of people treat those, especially the George Floyd killing, as a joke, right? They post really crass jokes and really terrible jokes about, George Floyd and George Floyd's killing and all that. That's all relevant. Like I said before, we don't have to find a place where somebody specifically uses a racial slur. We don't have to find a place where somebody says, I hate this group, or where they actively work against that group. We can, and we do, prosecute people based upon a totality of that. If you tell, all kinds of jokes about, African Americans and their perceived predilections or their perceived, social class or whatever, well, that's all racist, and we can put that all together to show that there's an increase in that. So yeah, social media has become very, very, very important for that. We use it quite a lot. I can tell you that all the civil rights hate crime prosecutions that I've looked at in the year that I've been in this job, every single one of them, we took a look at, social media for that. All right, so I've got a series of questions popping up in the chat. Let me roll back and kind of come through these. Carol asked, do you have knowledge of how Jackson's reported hate crimes compared to similar communities? I do not. I don't have access to that level of statistics here. I will maybe look that up and maybe put that out at AllPac, because I can get to it. It just requires a lot of fiddling. What I can tell you, though, just from a pure law enforcement standpoint, we do have a very good relationship with both Jackson PD and Jackson County Sheriffs, and they are very good about reporting things that may rise to this level to us. So I would hesitate to comment from my point of view, because ironically, the communities that do well with racial justice are the ones that I hear from the most often. So I would have a bit of a skewed view of that. But I will try to find the actual statistics on hate crimes and either get that to you or talk about it at AllPac next time. All right, so Shelby asks, would it be a hate crime if a religious group attacks LGBTQ during a pride event because it went against their religious beliefs? Presented with that set of facts, without context, yeah, I would absolutely consider that to qualify under a federal hate crime. When we talk about attack, let me do mention here that we would have to have a physical bodily assault. Couldn't be yelling, can't be signs, can't be protests. That's all covered under first. But absolutely, if they attack an LGBTQ group because of the LGBTQ-ness of the group, I suppose, absolutely, that would be something we would look at under Shepard-Byrd. Religion does not offer blanket protection there. We do see some confusion within the federal legal system about religious freedom, right? There are things that we excuse when religions do it that we wouldn't excuse if other groups do it, but that never arises to bodily assault. That never arises to shutting down other people's, rights under the Constitution. So, yeah, if we had a religious group, regardless of the religion, attacking LGBTQ members because of their LGBTQ-ness, that I would definitely consider that under Shepard-Byrd. Okay, so I'm just reading Frank's follow-up here. Oh, yeah, okay. I do remember this one now. You're right, it is in South Carolina. I have not read up on this case in some time, but I'm almost positive that he did get federal hate crimes charges put on him. I will look that up a bit, and you know, maybe that might be a nice one to talk about as we do as we talk about this more. And Frank, I'll do a deeper dive into that case, and again, either respond to you personally or perhaps we can talk about it at All Pact. Regina asks, what additional protections will this Equality Act provide us? I have no idea. I haven't read it yet. I do know that a big part of it was to strengthen the protections around sexual orientation and gender identity. If I had to guess, and if I win this, somebody has to buy me a cup of coffee. I would guess that it probably elevates sexual orientation and gender identity to the same level that we do with racial stuff, which is to not require interstate commerce as part of that. But I could be wrong. Okay, Ruth, am I familiar with the Metropolitan Equality Index? I am not. I have not heard of that. I would be interested to learn more. So Carol, I think you asked that question. If you wouldn't mind maybe sending me some literature on that, I would love to read up on it. Municipal Equality Index. Okay. All right. So that's everything in the chat. What else do we have from anyone here about anything?
So I wrote another one down too.
Please.
Talking about that interstate commerce, what are some other examples besides, you know, the transporting of a gun, a weapon, or things like that? What else is under that?
Well, you know, one that I did not mention specifically, which I should probably throw in there, is the internet, just as a general statement. You know, the internet, anytime that you use the internet, in the vast majority of cases, you are affecting interstate commerce. We had a little bit of a ruling sometime back. I won't tell you how long back because that would tell you how old I am and it's embarrassing. But we did have a ruling sometime back where we had to prove that the transmission physically exited a state and then re-entered it. So at one point I had to prove that, like, if you emailed somebody via Gmail, it had to go to a server in California and come back. We no longer have to do that, right? The interstate commerce clause has now been interpreted to just cover transmissions via the internet. I will place one caution on that, and I don't want to get too technical here, although it's one of my favorite things in the world. A communication that only goes across a local network that doesn't touch the actual internet doesn't automatically qualify under interstate commerce. Where we get by that one, however, is we just have to track down the manufacturer of the equipment used to send that, and then that would qualify as interstate commerce. So effectively, anything that's done over, you know, via or with the internet would count. Similarly, the telephone system would also count. That would include faxes, if anybody still faxes. The postal system, using the postal system automatically elevates something federally. I'm trying to think of what other edge cases there are. You know, the interstate highway thing, I think, throws a lot of people. You know, if you commit a hate crime while standing on I-96, that counts. And the interstate highway system doesn't mean that the highway itself exits the state. It means that it's part of the federal interstate highway system. So I think I-96 is a wonderful example because I-96 never leaves the state of Michigan, but it counts as an interstate highway. What else?
Anything else?
All right. Well, hearing none, I'm going to turn this back over to Carol in 1 second. But as a wrap up, first of all, thank you for your time and thank you for these wonderful questions. I will look into some of the questions that you guys answered. I'm sorry, that you guys asked. Hopefully, we'll have answers for you again, either via email or at one of the upcoming All-Pac meetings. Past that, if you have questions, please feel free to email me. Several of you have my business card. If not, you get it from Carol, or you know, we're in the phone book. If you have something that you think may be a hate crime that may, you know, rise to federal attention, I don't give these talks to discourage people from calling us or reporting things to us. I want you to call and report things to us. We may tell you that it doesn't rise to the level of a federal hate crime, but I'd rather hear more of them and tell you more no's than have you not call us. Let us make that call. If you do have questions after this, thoughts, comments, hit me up at AllPacked, drop me an email, give us a call. Happy to talk to anyone. So Carol, I will toss it back to you now.
That was absolutely fabulous. Thank you so much, Pat. And yes, we were kind of direct with you there. So I'll bring you a coffee next time I can. We meet in person. I owe you a coffee.
Whenever that is.
Whenever that is, I owe you a coffee. So thank you so much. And if anyone else has any questions or anything, I guess that'll be it for the night. So I want to thank, I've seen things, they're all popping up here on the chat for you, I think, to thank you. So, okay, so thank you so much. And I'll be talking to you soon, Pat. And thank you everybody for attending and asking questions, and felt like a really good night. Thank you so much.
Yes.
Thank you.
Good night,
Thank you,
everybody.
everybody. Appreciate
Good
it.
night.
That missed it, it is on our Facebook page, and it's recorded, and eventually it will be on our YouTube as well. So that's how you can access it. Thank you.
That's why I stopped taking notes, because